Hello, this is Matt on the Moon Family Sedan channel. XRP should be relisted on Coinbase, and frankly, it should be relisted on every exchange that halted trading or delisted it. It should be tradable again. And I'm preaching to the choir, I know. We get it. We're in the know. We've been following the SEC v. Ripple case for over 2 years. We're basically all effectively lawyers at this point, right? I know, not literally, but I tell you what, I sure know a whole hell of a lot more about securities law than I ever thought I'd know. That's for damn sure. And I'm sure you probably feel pretty similar if you've been following the case even halfway closely. But we're not the only ones that think that this would be the right approach. In fact, LBRY, which lost to the SEC this past November, believes and stated publicly that that Coinbase should absolutely relist XRP. So there's that, and I also want to share with you, because there are a bunch of comments around that I want to share with you, but then there's also this story. This is from Bloomberg, but it was covered by all the crypto media as well. Coinbase wins dismissal of lawsuit over unregistered securities. Now, the reason that I want to highlight this, and I probably would have given it a blurb, there's a good chance anyway, even just the nature of the case being what it is, because it's interesting, it's a legal thing that's in the news. But as it turns out, this case, it looks like it's directly going to impact some XRP holders. I kid you not, and I will explain why. But before going further, I do want to be clear, I do not have a legal or financial background of any kind. I am not offering legal or financial advice. And you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. So first I wanted to share this tweet. This is from January 31st from the official LBRY account. And mind you, you do need to know this to have proper understanding for what's going to be covered in this video. It's actually crucial that you understand this. And I know most of you are aware, but I got to just quickly properly set the table here. That there was a hearing just within the last few days. It was on January 30th, actually. And in the SEC v. LBRY case, there was a hearing for what would basically be called the remedies portion. Because mind you, again, like I said, in November, the SEC already defeated LBRY. So now we're talking about, okay, what penalties are going to be levied against LBRY? Is there going to be disgorgement? What's this or that? What's it mean for secondary markets? Now, there's a major win on that front, and attorney John Deaton was actually there because he was representing somebody as amicus in the SEC v. LBRY case, actually. And based on that conversation, it actually resulted ultimately in the judge pressing the SEC and the SEC admitting that secondary market transactions, meaning, transactions from like you and I or you and an exchange, the secondary market transactions not having to do with LBRY from the get-go, those are not part of his ruling. So they're not securities violations. That's a major win, actually, for anybody that cares about the long-term viability, certainly of LBC itself, but has implications for broader crypto markets. And of course, this will be brought to the attention of Judge Annalisa Torres in the SEC v. Ripple case. And so that's very big, very important news. Now, LBRY wrote the following. Many are calling yesterday a victory for LBRY, but we haven't won yet. It doesn't matter if the judge says LBRY credits is not a security if third parties, exchanges, etc., are still too terrified of the SEC to work with it. That's the real test. And attorney John Deaton agreed. He retweeted that and said, I agree 100%. If there was ever a utility token, it is LBC. How many professional traders or retail investors were speculating on the price action of LBC? Does it equal a 10th or 100th of ETH, XRP, Cardano, etc.? Professional crypto traders have never heard of the LBC token. Yeah, and that's an excellent point here. Now, if you look at what was stated, and find technically there is one little caveat, we do need to see the actual written ruling from the judge and regarding the penalties and remedies portion of this lawsuit, whatever you want to call it. But if he does what he said on the record in court he's going to do, and by the way, that transcript will be released at some point. If he does what he said he's going to do, then it is crystal clear that LBC transactions that aren't touching LBRY, so whether you're an exchange or just individuals transacting, however you're using it, that is not part of the judge's ruling in the SEC's victory. It is not. He says he's going to write it out so it's explicitly very clear. That should be all the clarity that exchanges need to relist the LBC token, because the judge is explicitly stating there is nothing against those transactions, clear as day. And in order for the exchange to prove that they're not in violation, they just have to prove they're not LBRY. That's it. And by the way, LBRY is about to, well, they're about to cease to exist for the company, not the LBC token, but LBRY. So but if you're an exchange, you look at the judge's ruling, it only applies to LBRY and then whoever that would have gone, those sales would have gone to. So if you're an exchange and you just have LBC now, and you're second market, in secondary markets, clearly, and the judge says he's going to make this crystal clear the way he writes it, you're not part of that. So exchanges should be relisted, but you see the fear here, right? And this could happen in the Ripple case too. The fear is that going to be sufficient for exchanges to relist LBC? And I sure as hell hope the answer is yes. We just don't know for sure. Because, the only thing that would have been a little bit nicer is if you declare that the token itself isn't a security, but the judge wouldn't technically do that because he said he's a minimalist, as reported by attorney John Deaton. But it has the same net result because, again, if those aren't violations, that means just by simple logic, they can't be securities because if the asset itself were a security, then every transaction would be a security. So it's clearly the case that the asset itself is not a security, just using simple logic based on what the judge has said here. So it should be the end of this. I just don't know for sure, because then are you going to worry because you know how terrible and vindictive the SEC is if you're an exchange that relists, are you going to get attacked anyway? Now that would be a harder one for the judge for the SEC rather to win. But that's something where like we as XRP holders, we could be put in that situation. Like say Ripple loses, and Judge Annalisa Torres ends up coming to the same conclusion and words it similarly. Okay, well, are exchanges then going to relist XRP? And then there's other ways it could go too, because there could be an agreement between Ripple and the SEC. Like say Ripple loses, and I don't know if they're going to lose, but say Ripple does lose. Well, you could have a situation agreement in which Ripple says, okay, we agree, just in so many words, acknowledge that the token itself is not a security, or that this just applies to specific transactions have to do with Ripple, and then we won't appeal. And I don't know if the SEC would agree to that, but if they would, then that could be a path forward for XRP holders too. But is it going to be enough to, outside of that, is it going to be enough for XRP to be relisted even? That's the concern. And so then LBRY also, so they tweeted this out, and this is what got everybody talking, including myself, of course. LBRY just yesterday tweeted out, Coinbase should relist XRP. Under the SEC v. LBRY standard, XRP sold by secondary holders is not a security. And folks, that is true. By the LBRY standard, not a securities violation. Definitely not. So we'll see what happens here. And then LBRY also tweeted this out. Why SEC is going against Ripple and now against LBRY? You know why? ? They don't like the idea of decentralization because LBRY, LBC, does to publishing what Bitcoin does to money. But guess what? They hit the wall. Thank you, John Deaton. Thank you all. Yeah, and so I do like how the degree to which the XRP community has rallied around what's been happening with LBRY. That sure as hell is true. And as far as the reasons, I'm perfectly happy to speculate on what's going on. I have. But to me, it just seems like personal motives. I mean, yeah, there may be some people. I'm not saying the LBRY is wrong here. That could be a piece of it. It just depends on which individual you're talking about. Like in the case of Kim Jong-Ginzer, I just think he's doing what's in his own personal self-interest, and he's carrying the torch that was lit by Jay Clayton, former SEC chair, and Bill Hinman and all them. And so that may very well have been the case here. But I also think there could be other stuff like Attorney Deaton was talking about in terms of their friends in legacy finance that haven't gotten a crack at crypto yet. Is that something to consider as well? Well, it's certainly worth discussing. It's very well a possibility. So there's a lot of things that it could be. It's perfectly reasonable speculation regardless here. Either way, it's not right, and it's outside of what legal precedent would have you believe should be done, right? If we're being intellectually honest here. Now into this, and this it will impact, from a legal perspective, some XRP holders. And you'll see why. Let me go through this thing, but this is interesting. So there's this headline from Bloomberg. Coinbase wins dismissal of lawsuit over unregistered securities. Coinbase Inc. won dismissal of a lawsuit by consumers alleging the cryptocurrency exchange facilitated the sale of unregistered securities on its platform. The proposed class action suit filed in federal court in New York in October 2021, seeks damages arising from the sale of soliciting of 79 digital assets that the consumers say amounted to illegal contracts because the platform is not registered with the U.S. Securities and Exchange Commission. U.S. District Judge Paul A. Engelmeyer didn't make a determination about whether the digital tokens were actually securities, though he said he assumed they were for the purposes of the dismissal request by Coinbase. So I'll pause to note that might sound bad on the surface, but it's, from a legal perspective, effectively non-consequential. There's nothing binding about whether something is or is not a security. Just for the sake of the argument, he made the assumption that they were, so that he could get to the conclusion that he needed to get to throw this damn thing out because it is nonsense. And so the piece continues. Had the suit been allowed to proceed, the question of whether they are securities would have been a central battleground, he said. That would have been interesting. That definitely would have been not necessarily good, but it would have been interesting. Engelmeyer said the terms of Coinbase's user agreement flatly contradict allegations in the lawsuit that the company holds title to the digital assets that are bought and sold on the exchange. The judge also found that the platform didn't actively solicit investments. So this is so that's the part that ends up makes it relevant to certain XRP holders. Because again, the part that says how's it worded exactly? The company holds. So the Coinbase user agreement flatly contradicts allegations in the lawsuit that the company holds title to the digital assets that are bought and sold on the exchange. Right. So it's the users that hold the crypto, which is why whether or not they're securities is inconsequential, because it's not the exchange's property, it's not a contract with them. In that sort of regard, it's the user's stuff, effectively, even though they're facilitating transactions. That's the conclusion, effectively, that the judge came to, which is why it was thrown out. But what does that mean for Songbird tokens and Flare tokens? Because Coinbase hasn't handed out any of that. Now, they have not said a peep about the existence of Songbird in terms of distribution. Nothing whatsoever. They haven't said they're going to or not going to. And Songbird was distributed in September of 2021. So they're just pretending that it didn't even happen. That's how terrible they are. That's, from a customer service perspective, it's repulsive and disgusting. And as far as Flare, they say that they're going to have it distributed by the end of the first half of this year. Other exchanges, they distributed it the day that they received it. So they gave it to their customers. Coinbase just isn't treating customers well, and for some reason they don't give a damn. They just don't. We could talk about the reasons why, maybe in a separate video, but they don't give a damn. So, but again here, Coinbase has already argued that they don't hold title to the digital assets that are bought and sold on the exchange. And in fact, take a look at this. This is a tweet from Paul Gruhl, the chief legal officer at Coinbase. And he said in this tweet just yesterday, "We appreciate the federal court's careful consideration and affirmation of what our user agreement makes abundantly clear. Coinbase does not hold title to customer assets." Well, that's interesting, because they're holding customer assets. They're holding Songbird tokens, and they're holding Flare tokens that they've not distributed. And it doesn't look like they have any intention of distributing Songbird tokens, and hopefully they follow through with Flare. They should have done it by now, but they just haven't. And so XRP community member and attorney Fred Rispoli retweeted that. And mind you, he's going after Coinbase here. He literally, like, in case you hadn't heard, like, he filed the lawsuit because they've not distributed Songbird or Flare tokens. And so Fred Rispoli wrote, "Coinbase, you win some, you lose some. If you don't hold title to customer assets, then you are literally stealing customers' Flare and Songbird, which title flows through customers' XRP." And by the way, that sounds in line with what Fred Rispoli argued in the lawsuit against Coinbase. So just imagine it like this, like a somewhat reasonable analogy here, I think. Imagine if, something, say I want to send you a gift. Say it could be any number of things. I don't care what it is. It could be a fancy new, really expensive computer that's a couple of $1,000s. Let's say that's it. And I want to send this gift to you, and I send it to you, but it ends up, whether maybe I sent it to the wrong address or somebody else did, somebody else got it delivered to the wrong address, but then it goes to somebody else. It goes to somebody else, and that person's like, oh, well, it was sent to me. It's mine now. It's not a perfect analogy, but I think it's reasonable. There are a lot of important similarities there. So you send something, and it's intended for somebody else, but it goes to, it's intended for someone, but it goes to somebody else, and then that somebody else just keeps it because it's sent there. You can't do that. If something is sent to it gets to an unintended recipient. I'm sorry if it's a hassle for you, but you can't then just keep the product. Like you can't do that. And yes, it would be a hassle for you if that was sent and then you have to get it to the right person. It's the same thing if like mail's accidentally delivered to the wrong address in the United States anyway. You can't open that. It's not yours. Literally, it's not yours. And so just imagine if something of notable value is sent to an unintended recipient. Well, again, I admit it's not a perfect analogy, but you get the idea. It's not yours, damn it. But they're just keeping it because why not? They're Coinbase and they're awful. I mean, it's pretty gross what they're doing, isn't it? And I understand it's unfair that they're put in that situation, just like it's unfair when you receive mail that's not yours and then you have to deal with it and you're supposed to get it to the right person, or if it's an expensive package that's not yours and it's supposed to be sent to somebody else or somebody expects you to hand it to them. I get it. That's unfair and that's an inconvenience, but it doesn't make it right to then take it. That's the problem. Really grinds my gears, folks, so I'm glad that Attorney Rispoli is going after Coinbase, because I think it's just, especially from just an ethical perspective, it's disgusting what they're doing. And here you have Coinbase acknowledging that any crypto, from customers, it's customers, it's not theirs. And again, it's because of the XP that was held on the platform. So this actually, I think, just gives extra ammo to Attorney Rispoli from a legal perspective. So we'll see what happens here. But this is going to directly impact some XRP holders as a result, because this is going to be argued. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the Moon Family Sedan.